Okay, 900 long, excuse me, how can I help you? $900 long versus Ronige Holloway 24-04-837. Anybody present on those matters? Counsel, can I have your appearance?
Good afternoon, Judge Brent, on behalf of the plaintiff.
Your name, ma'am?
Ronige Holloway.
Ronige Holloway. Today's the date and the time that was scheduled for hearing. This is for non-payment of rent. Did you all come to a resolution?
We did, Judge. We're going to be entering a conditional order of dismissal, and I can put the terms on the record.
You can do so at this time.
Rent to retain, this is $8,638. Cost is $194.29 for a definite amount of $88.3309. The terms are that the defendant shall pay the amount stated on the record or vacate no later than 11/15/2024. She did sign this, and if I may.
Okay, and ma'am, that's how you want to proceed?
Yes.
You understand that you had the right in this matter to proceed to a trial. You could have demanded a jury trial.
Yes.
You also had the right to be represented by an attorney.
Yes.
Did you want to waive both of those rights? Anybody threatening you to do that?
No.
So you understand and you're agreeing that the matter will be dismissed today based on the condition that you will either pay the rent, past due plus court costs, in the amount of $8,833.09, or vacate the property no later than November 15, 2024, correct?
Yes.
And partial performance will not satisfy this, so that means that you either need to pay that amount in full or you need to vacate, removing all of your items and turning over the keys in the property in room swept condition before the 15th. You understand that?
Yes.
Do you have any questions about these rights? You have 3 days, 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return to the court, request to have this set aside, and we'll set it for a hearing. You can explain how you misunderstood your rights, okay? We'll get you a copy in just a moment and you'll be on your way. Any additional matters for the record?
Nothing further, Judge. Thank you.
You're all set. This is Baltic Flats versus Jamie Zamaraj, 24-05076.
Thank you, Your Honor. Good afternoon. Sam Dua here on behalf of the plaintiff.
What's your name, ma'am? Okay, today was the date set for hearing. This is for non-payment of rent. Did you come to resolution?
Your Honor, I had an opportunity to meet with the defendant earlier, and I think the best resolution at this point is to adjourn until November 13th or shortly thereafter if it is unavailable.
Okay, what is the purpose of the adjournment?
Just additional time for the defendant to seek assistance as well as a little bit of negotiation time.
November 13th at 2. November 13th at 2.
Sorry.
November 13th at 2.
That would be great. Thank you.
Do you have any questions today, ma'am? Okay, we'll get you a notice to appear. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Thank you. You're all set. Thank you. This is the matter of Lansing Towers versus Benny and Angela Poole, 24-05153. Counsel appearance.
Good afternoon, Your Honor. Robert Visconti, P61756, plaintiff. Defense counsel from legal aid is still speaking with his clients.
Oh, they're represented by legal
We
aid.
have it all but resolved.
Okay. Sounds good. I don't have an appearance from that, yes.
No problem.
Okay, thank you. Which matter are you here on?
Manor born, Your Honor. This is,
Matter of Manor Born Limited versus Jolie York, 24-05223. Appearances, please.
Thomas Becker, 53936.
And Alyssa Hull of Legal Services of South Central Michigan for defendant Julie York.
Today's date and the time that was scheduled, and this is for a hearing for non-payment of rent. Did the parties come to a resolution?
We have not, Your Honor. We are requesting a 3-week adjournment. Some certification issues, I think, should be resolved. Probably should be resolved.
Sounds good. November 13th at 2.
Thank you.
Any additional matters for the record?
Nothing for the Honor.
No, Your Honor, thank you.
You're all set. Uh, Okay,
Hearing now.
okay, on the record in the matter of Lansing Towers versus Vinnie and Angela Poole. 4-05153. Terrence, please.
Afternoon, Your Honor, Robert Visconti, P 61756, plaintiff.
Good afternoon, Your Honor. Sorry about that. Elijah Tyler, P 86242, on behalf of the defendants, Angela and Jenny Poole.
Okay, and then present in the courtroom today was the date that was scheduled for hearing. This is for non-payment of rent. Have the parties been able to resolve this yet? Or-
I believe so, Your Honor. Yes, ma'am.
Believe so, Your Honor, and I have the terms that I can place on the record. It's getting really messy, so I'm gonna type it up when I get back to the office tomorrow and email it to you, and then we can file it. Your Honor, the judgment is for possession only. It will reflect a rental arrearage of $5,557.43. Court costs of $193.43 for a total of $5,750.86. The parties have agreed to a payment arrangement whereby defendants will pay their prospective rent for the month of November by November 5th, $1,916.95 towards the judgment amount by November 22nd. December prospective rent by December 5th, $1,916.95 towards the judgment arrearage by December 20th. January rent, including a month-to-month fee of $100 as of going month-to-month that month, by January 5th, 2025, and the final installment of $1,916.96 by January 24th, 2025. Failure to make any payment set forth therein would allow the order of eviction to issue. If an order of eviction is filed in the case, at the same time that the writ is sent to the court for filing, we will contemporaneously notify counsel by email so that he is aware of it. And I believe that was. If the judgment is paid in full and all 6 of the payments are timely tendered, I will stipulate to set the judgment aside and cease the case after all the payments.
So that's complete and accurate as to what the resolution is.
Yes, ma'am.
Mrs. Poole, is that accurate and complete? Yes. Mr. Poole? This is a lot to reiterate, and it sounds like he's got to type it up and get it in writing. So just going to advise you of your rights today to make sure you understand them. You already have counsel, which is one of your rights. Your other right is to have a trial. You could have demanded a jury trial and have proofs put forth on the record before a jury or a judge. You also would use that time if you wanted to have a counterclaim or present any defenses to the non-payment of rent eviction. Do you want to waive your right to a trial? Okay, so that means you would also be waiving any counterclaims that you potentially discuss with your counsel. You understand that? Okay, and so you all are going to review and sign that or give your attorney permission to sign on your behalf? Yes, this resolution. Okay, you have 3 business days from the date that that's entered, not from today because it's not entered yet. 3 business days from the date that I sign that, you'll have to come back to the court. If you realize you misunderstood the rights you gave up, you can come back to the court file to have that set aside, and then we'll set it for a hearing, okay? Do you have any questions for the court? Ma'am? Okay, any additional matters for the record, counsel?
Brother, to me.
Thank you, you're all set.
Thank you so much.
Is there any way to tell you?
No, thank you.
I just want to say the last time I told you I saw you in here.
Nice to meet you. Nice to meet you.
Thank you, have a good one.
Absolutely. Sounds good.
You too. Thank you.
Thank you.
Okay, you got a couple more. Are they ready? Do
I
you-
have consent judgments on the two o'clock cases for Woodbridge with Alexis Smith and Jeremiah and Jemiah Scott.
Okay, this is Woodbridge Apartments versus Alexis Smith, 24-05155. Alexis Smith.
Robert Visconti, P61756 for the plaintiff.
We did that. And you're Alexis Smith, correct? Okay, today was the date and the time that was scheduled for a hearing for non-payment of rent. Counsel, can you put the terms of the resolution in the record?
Yeah, to your honor, we have a proposed consent judgment for possession only. Rents retained in this case is $1,358. Court costs are $174.54 for a total of $1,533.54. Judgment for possession only with an order of eviction to issue if that amount is not paid in full by November 4th, 2024. Do you have an order prepared that's been signed by both parties?
Okay, that's accurate. That's how you want to proceed, ma'am? You have the right to be represented by an attorney in this eviction proceeding. Did you waive your right to counsel? You also have the right to proceed to a trial. You could have demanded a jury trial in this matter. Are you going to give up your right to trial in order to enter into this consent judgment? Anybody threatening you to do that? Any promises being made to you to give up your right? Okay, so you agreed to have judgment entered against you by consent, whereby you agreed the amount to retain possession of the property of 525 East Edgewood Boulevard, apartment 816 is due in the amount of $1,358 plus court costs of $175.54 for a total amount due $1,533.54 that you'll pay that or vacate the property in question no later than November 4th, 2024, correct? You have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights that you just gave up, you can return to the court and request to have this agreement set aside, and we'll set it for a hearing, okay, ma'am? Do you have any questions for the court? We'll get you a copy of that in just a moment. Any additional matters for the record, counsel?
Nothing further.
You're all set, ma'am. On the record in the matter of Woodbridge Apartments versus Jeremiah and Kamaya Scott, 24-05158.
Afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
Please state your name, please.
Jeremiah Scott.
Today's the date and the time that was scheduled for hearing. This is for non-payment of rent. How will you proceed?
Your Honor, we have a proposed consent judgment for possession only in this matter. Judgment reflects a rental arrearage of $1,862.09, court cost of $193.43 for a total of $2,055.52. Judgment for possession only with an order of eviction to issue after November 4th, if not paid in full. I do have an order prepared that's been signed by both parties.
And that's correct as to how you both want to proceed? Okay. So you both have the right, excuse me, in this matter to proceed to a trial. You could have had a jury trial. You understood that, right? Yes. I need verbals for both. Thank you. And you also understand that you had the right to be represented by an attorney in this matter, correct? And are you both going to give up your right to be represented by counsel? Okay, and give up your right to have a jury trial? Anybody threatening you to do that? You have 3 business days from today's date. If once you leave here, you realize that you misunderstood either of those rights, you can return to the court and request to have this set aside. Otherwise, judgment will enter by consent, whereby the past due amount to retain possession is due in the amount of $1,862.09 plus court costs of $193.43, a total amount due $2,055.52, and that you'll pay that in full or vacate the premises completely by November 4th, 2024. Do you have any questions? We'll get you both a copy of this and you'll be on your way. Any additional matters, counsel?
Nothing further on this matter, Your Honor.
Thank you. You're all set. Mr. Dua,
Yes, Your Honor.
someone was here early, correct?
Yes. It's a 3:30 case.
You ready?
We have a signed CD, so.
Okay, on the record in the matter of Aspen Flats versus David Wondergem, 24-05259. Have your appearance, please.
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
Then Mr. Wondergem is present in the courtroom.
Yes.
Okay, today's the date that was scheduled for a hearing for non-payment of rent. Mr. Wondergen showed up almost 20 minutes after you left this morning, ready to go. But nonetheless, you guys got this resolved now.
Yes, Your Honor.
We put the terms on the record.
Thank you. Your Honor, very simple conditional dismissal signed by both parties. Says that rent due through the end of October is $1,116.85. Costs $183.07. Total $1,299.92 to be paid in full on or before November 4th, 2024. Box 4B is checked. Box 7 for partial payments are not adequate to satisfy the conditions is also checked. May I approach?
Yes, please.
Thank you.
And Mr. Wonder Jim, is what Mr. Dewar stated accurate as to how you want to resolve this? So you have the right to be represented by an attorney. Are you waiving your right to be represented by an attorney in this matter? You also have the right to demand a jury trial or have a non-jury trial on this matter. Are you going to waive your right to trial?
Yes.
Okay, so the matter, based on your agreement, will be dismissed today upon the condition that you either pay the amount of past due rent plus court costs of $183.07 for a total amount due $1,299.92. That's for rent due and owing through October 31st of 2024. That you'll pay that in full or vacate by November 4th, 2024, correct? Partial performance by you would not satisfy this. So you either have to pay the full amount of $1,299.92 by the 4th of November or vacate by the 4th. You understand that? Do you have any questions about your rights? You have 3 business days from today. If once you leave here, you realize that you did in fact misunderstand these rights, you can return to the court, request to have this set aside, and we'll set it for a hearing. We'll get you a copy of that in just a moment. Any additional matters for the record, counsel?
Thank you. Nothing further.
You're all set. Woodbridge Apartments versus Caprice Bowser, 24-05161. Appearance for the record.
Good afternoon, Your Honor. Robert Visconti, P61756.
And your name again is Caprice Bowser?
Yeah.
Okay, today's the date that was scheduled for a hearing for non-payment of rent, and you have a resolution.
We do, Your Honor. Ms. Bowser has made significant payments today, and she has reduced her balance to a total of $177.70 for rents retained, costs of $175.54, for a total of $353.24. We have a proposed consent judgment for possession in that amount. We agreed to extend the vacating matter to November 8th. And I do have a judgment that's been signed by both parties.
And that's how you want to proceed, ma'am?
Yeah.
Okay, so you have the right in this matter to be represented by an attorney. You've appeared without counsel. Are you waiving your right to an attorney today? You also have the right to proceed to trial. You could have demanded a jury trial, or you could have proceeded to a bench trial, which is a trial by judge. Do you want to give up your right to be to have a trial in this matter? Anybody threatening you to give up either of those rights? So you agree to have judgment entered against you today for past due rent still owing in the amount of $177.70 plus court costs of $175.54 for a total amount due $353.24. You'll pay that, or you'll vacate the property no later than the 8th of November, correct? Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood any of the rights that you just waived, you can return to the court and request to have that agreement set aside, okay? We'll get your copy of it in just a moment. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Thank you. All right, yes, that's it. Ms. Withers, we're just waiting for the attorney to log in to meet with you privately.
Okay.
We have Mr. Dewar.
Mr. Williams. Right, Robert Williams?
Oh, okay, I see. Okay, on the record in the matter, Carolina Flats versus Ronald Williams, 24-05231, counsel appearance.
Thank you, I understand. Joe here on behalf of the plaintiff.
Sir, state your name for the record.
Ronald Williams.
Okay, Mr. Williams, there was a date scheduled for a hearing. This is for non-payment of rent. Mr. Dewar, how are you going to proceed on this?
Thank you, Your Honor. I had an opportunity to speak with the defendant, and we have both entered into and signed a proposed consent order for conditional dismissal for your review. The document states that the current rent due in 2A is $5,362.94. Cost $178.05. Total $5,540.99. Which is for the time period through October 31st, 2024. That amount will be paid or the defendant will vacate on or before November 19th, 2024. Box 4B is checked along with box 7 saying that partial payments will not prevent this agreement from being in default. Again, both parties have signed. May I approach?
Yes.
Thank you.
Okay, Mr. Williams, what Mr. Dewar said is accurate as to how you want to proceed in this matter.
Yes, Your Honor.
Okay, so the matter will be dismissed today upon the condition that you pay past due amount owed $5,362.94 for court costs of $178.05 for a total amount due $5,540.99. That you'll pay that or vacate the premises of 2121. I'm sorry, wrong address, 2514 Rysdale Avenue, Lansing, Michigan, 1 November 19th.
Correct.
Okay. You had the right to be represented by an attorney today. Did you understand that?
Yes, Your Honor.
You want to give up your right to be represented by an attorney?
No, Your Honor.
You do not? You want to go and give an attorney?
No, I do not.
Okay, so you want to give up your right to be
Yes, ma'am.
represented, okay. And then you also have the right in this matter to proceed to trial. You could have demanded a jury trial, or you could have had a non-jury trial. Did you want to give up your right to have a trial in this matter?
Yes.
Anybody threaten you to give up these rights?
No.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood these rights, you can return to the court, request to have this set aside. We will set it for a hearing. Partial performance will not satisfy this agreement. So that means you have to pay the amount in full in 2D, or you need to vacate by the date of November 19th. You understand that?
Yes, Your Honor.
Do you have any questions? Any additional matters for the record?
Nothing further, Your Honor. Thank you.
We'll get you a copy in just a moment. And then we have Ms. Withers on Zoom.
Yes, with your permission, I'll jump on the Zoom from the conference room.
Thank you.
Thank you. Thank you. You have a blessed day.
Thank you, sir. Okay. Ms. Withers, I need there to be some light so I can see you.
Okay.
On the record, in the matter of Carolina Flats versus Unique Withers, 24-05237.
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
Okay, and the Unique Withers is actually present via Zoom. I think she notified the clerk's office of a medical issue. Today was the date and the time scheduled for hearing for non-payment of rent. How did you all decide to proceed on this?
Thank you, Your Honor. I do have an agreed upon consent order for conditional dismissal. I have the permission of the defendant to sign, which I'm doing right now. Proposed agreement states that rent in 2A through October 31st, 2024 is $4,726.57. Court cost 2B, $179.05. Total 2D, $4,905.62. The agreement is that the defendant will either pay or vacate the premises located at 4301 Richmond Street on or before November 11th, 2024. Box 4B is checked. Box 7 for partial payments not satisfying this agreement and putting it in default is also checked. I have signed. I've also written that we have the permission of the defendant on the court record, which I presume she'll give here in just a minute, and I've signed my name on that.
Thank you.
Thank you.
Okay, Ms. Withers, is what Mr. Dua stated accurate as to how you want to proceed in this?
Yes.
Okay, so you have the right in this matter to proceed to a trial. You could have demanded a jury trial. Did you know that?
I'm sorry, what was that?
You have the right to proceed to trial in this matter, and you could have demanded a jury trial. Did you know that right?
Yes.
And you want to waive that right, meaning give that right up in order to have this agreement entered?
Yes.
You also have the right to be represented by an attorney. Are you waiving your right to counsel on this?
Yes.
Okay. You are agreeing to have the matter dismissed today upon the condition that you'll pay the past due rent in the amount of $4,726.57 plus court costs of $179.05 for a total amount due through a time period of October 31st in the amount of $4,905.62. You'll pay that in full or vacate the premises of 4301 Richmond Street, Lansing, Michigan, on or before the 11th of November. Is that accurate?
Yes.
Okay, you've given Mr. Dua permission to sign this conditional dismissal on your behalf in your absence, correct?
Yes.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you have just given up, and you want to have this set aside, you would come to the court, file a motion to set aside this agreement and explain to the court how you misunderstood your rights. Lastly, partial performance will not satisfy that agreement. You must perform completely by paying either the amount fully stated in section 2D, or you need to vacate the property by November 11th. You understand that?
Yes.
Any additional matters for the record, counsel?
Thank you.
Thank you. You're all set.
I got an email about one of these cases.
No worries. I saw your reading.
Yeah.
Okay, you're all set, ma'am.
Okay, thank you.
You'll get a copy in the mail.
Okay.
Anytime, are you ready? On the record in the matter, Carolina Flats versus Aaliyah Pugh, 24-05226, appearance please.
P 86242, Elijah Tyler on behalf of the defendant of the accused.
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
Okay, and Ms. Pugh is present in the courtroom. This is a hearing for non-payment of rent. How are we proceeding?
Thank you. I thought we were doing Washington, so I didn't know. I just need 1 second to fill this out. Put everything in?
I will put, so that's. We do it too, and that so far we will also put in the sheet in the payment system. So,
That's on here, number 30.
yeah,
You can open
we're the web-
the door. You can open the door.
Sorry, I was not.
That's okay.
You were asking.
Reset that. Sorry, I put it in there, I just never.
I probably could have written it a little bit more eloquent, but hopefully everybody will understand that. Thank you.
I know I asked if y'all needed more time about 5 minutes.
I'm so.
I thought that we were putting the Washington one that we had already
I
submitted
did, I
on
did.
the,
I
on
was
the
like-
record.
And then you said Q.
And so we tried to scramble, but
Washington, or what is Washington? Oh,
Yeah.
is Chelsea Washington here?
She is.
Okay, yeah, but Q was scheduled for 2:45.
no problem. We're ready.
We're
now.
ready.
Okay,
I'm
sounds
sorry.
Apologize. Sorry for the.
How are we proceeding on
Thank
Q?
you. Your Honor, I had an opportunity to meet with Mr. Tyra on behalf of the defendant, and we've come to terms on a proposed conditional dismissal that simply states that the defendant will vacate the premises located at 2606 Risdale, Lansing, Michigan 48911, either on or before November 30th. The defendant will deem to have vacated the premises once she turns the keys in. However, in order to get that date, the defendant agrees to pay 1 month's rent, $1,050 on or before November 15th, 2024. So in other words, if the payment is made on the 15th, then she's welcome to stay till the 30th, and she'll vacate on or before that date. And if not, then it would be a default. We would move for default on as early as the 16th.
Oh, that's accurate?
May I approach?
Yes.
Michelle.
Thank you. Okay, so you, ma'am, are agreeing to have the matter dismissed today upon the condition that you will vacate the premise of 2606 Wisdale Avenue, City of Lansing, either on or before November 30th, 2024. The defendant will be deemed vacated once the keys are turned in. The defendant agrees to pay $1,050 on or before November 15th to get the date to vacate of November 30th. Is that accurate?
Yes, Your Honor.
Remind me again, what happens if she doesn't pay the $1,050?
We would simply move for a default on the first business day after the 15th and request the immediate order of eviction.
Okay, I just updated the language to reflect that, to make it clear for the clerk's office as well.
Thank you.
Okay, and so you understand that if you do not make the payment of $1,050 by the 15th, that they can move for default and judgment to enter against you, and that they don't need to notice you of a new court date. You understand that?
Yes, Your Honor.
Okay, and so you have the right in this matter to proceed to trial, and you have the right to a jury trial. But you want to give up your right to a jury trial? Or do you want to have a jury trial? Okay, so you want to give up your right, okay. Okay, anybody threatening you to get you to give that right up?
No, Your Honor.
Okay, and you fully understand that partial performance of this agreement won't satisfy? You have to do everything that you said you were going to do in this section. Otherwise, default can enter against you without them noticing you of a new court date. You understand that?
Yes, Your Honor.
Okay, you have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights you gave up, you can return to the court, request to have that set aside, and then you will explain how you misunderstood your rights, okay?
Okay.
We'll get you a copy of your notice in just a moment. Do you have any questions?
No, Your Honor.
Any additional matters for the record?
Nothing further. Your Honor. Thank you.
Thank you. You're all set. So you're ready on Washington?
I think we had submitted that on my file.
We did, and I wasn't sure I saw it still, I was part of the calendar for today.
It's on my, Chelsea Washington?
Yes.
She's on my calendar. We can't enter a conditional or a judgment or conditional dismissal without her here.
Okay. Sure, no, I was just picking up on my file too.
I do not.
I don't have it either.
I have it.
Okay.
Okay, wonderful.
On the record in the matter of Aspen Flats versus Chelsea Washington, 24-05261, council appearance.
Thank you. I understand. Do I hear you?
Thank you, Your Honor, Elijah Tyler, PA 6242, on behalf of the
And you are Chelsea Washington?
Yes.
Okay, Ms. Washington, today was the date that was scheduled for a hearing for non-payment of rent, but the court was in receipt of a consent order for conditional dismissal. It says that you are agreeing to have the matter dismissed today upon the condition that you pay the past due rent, $4,402.65, plus court costs, $183.07, and that's for rent due through the time period of October 31st, 2024. That's a total amount due, $4,585.72. It says that the defendant agrees to continue to work with Avon House Ministries to secure rental assistance for their arrearages through the month of November this year, 2024, either on or before November 30th, 2024. Plaintiff agrees to exterminate rodent infestation in defendant's home within 6 months with a method more effective than the current spray. That's accurate as to how you want to proceed?
Yes.
I think you signed this, or you've given permission for your attorney to sign, correct?
Yes.
Okay, and so you had the right in this matter to proceed to a trial. You had the right to a jury trial. Do you understand that?
Yes.
Okay, and you understand that by entering this agreement, you would have to give up your right to a jury trial?
Yes.
That includes waiving your right to any counterclaims or defenses to the non-payment of rent. You understand that?
Yes.
Okay, and you understand that partial performance under this section will not satisfy the agreement, meaning you have to do all the things that you said you were going to do, which is paying the full amount in 2D and doing what's in section 3 as well. You
Yes.
understand that?
Yes.
Otherwise, you will need to vacate the property and turn over the keys. You understand that?
Yes, ma'am.
Okay. Let's see. Anybody threatening you to get you to give up your right to an
No.
attorney?
No.
Any promises being made if you give up your right? I'm sorry, not right to attorney, right to a trial. You are represented. Okay. Any promises being made for you to give up your right to trial?
No.
Okay. Again, you have 3 business days to return to the court. If once you leave here, you realize that you misunderstood the right that you just gave up, you can return to the court, request to have this set aside, okay?
Okay. Thank you.
No problem, I just signed it electronically. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Thank you.
You're all set.
Come on, hey. Come on.
Oh my gosh, oh, this is so, wow.
Yes, sir.
It's Mr. Level. What's your name?
My name is Christian Bloom.
It's Christian Nuabo.
Yes.
Very good. Mr. Dua has names.
So that's one.
I don't see Ortiz on my file, on my document. Oh, that was at 3:15. That's Mr. Tyra's matter with Mr. Dua, so hopefully they've worked that out.
Yeah, they were doing conditional dismissals.
Okay, do we have anybody in the hallway for William Bragg or Tamara Stinson? Brad? What's your name?
Tamara Stinson.
What's your name? Okay, do you have an attorney?
Yeah, he just walked out with the other lady.
Is it Mr. Tyra? Okay, you can have a seat back there.
Oh, okay.
You can tell them we can do the arraignment. I think it's our file anyways.
It's your file.
I believe so, but you can let them know we'll do the arraignment.
Oh, man. Yeah, yeah. Okay, whatever.
Mrs. McCarr Ortiz. On the record in the matter of Aspen Flats versus McCarr Ortiz, 24-05253, counsel appearance.
Thank you, I understand. Do I hear for the plaintiff?
Elijah Tyler, PA 6242 on behalf of the defendant.
There was a date scheduled for a hearing for non-payment, right? Did you all come to resolution on that?
You did, Your Honor. The pertinent terms of our agreement states that the defendant agrees to vacate the premises located at 1400 West Georgetown Boulevard, apartment 11, either on or before November 15th, 2024, and that the defendant will be deemed to have vacated once the key is returned.
That's accurate.
It is, Your Honor. Thank you.
And 4B and 7 may approach.
Yes,
Have been explained to the parties.
thank you. And Ms. Ortiz, that's how you want to proceed? Okay, so you're going to give your right to have a jury trial in this matter? I'm asking you.
Oh, yeah, sorry.
You don't have to. If you want a jury trial, we can call a jury in for this if you like. Do you want to do that?
No.
Okay, so you want this matter to be dismissed today upon the condition that you'll vacate the premises on or before the 15th of November, and that you will turn over the keys. That will be what deemed you as vacated the property. You understand that? Okay, and you understand that partial performance won't satisfy this, meaning you have to vacate, removing all of your items, including trash items, and turning over the key. You understand that? You have 3 business days from today's date. Once you leave here, you realize you misunderstood the right you gave up. You can return to the court and request to have this agreement set aside, and then we'll set it for a hearing. Do you have any questions, ma'am? Get your copy of that in just a moment. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Your Honor.
You're all set. And then you have one more matter.
Yes, ma'am.
They're ready to go?
Do you mind if I take a second to talk to the opposing party? Because we've
Absolutely.
not had a chance to.
And Mr. Dewey, you had one more matter too?
Yeah, sure.
I just
Oh,
see
no.
one. You did one, did you already?
One is of Buchanan. I better get on it.
Oh,
Yes, you're good.
Mr. Dillon.
Yes, thank you so much. Appreciate it. I'll be back.
and then it's
Good.
nowhere. They're trying to bake us in here. I am routing this back to you. I don't see your signature stamp on it. These are like 2 or 3. You said the files are ready. Okay, on the record in the matters of the people of the state of Michigan versus Kelsey Alvarado, I have 24-02082 first. How are you, Miss Alvarado?
Good, how are you, Your Honor?
Doing pretty good. I haven't seen you in a while. Okay, this was a dog at large matter that was scheduled, it looks like, for an arraignment back on August 16th. But you failed to appear. Why is that?
Yes, Your Honor. I was currently, I've just been struggling since I was incarcerated and I got out. I was in a relationship and the relationship that I was in had to rack up all my bills and my things got shut off. So I was staying at my dad's at that time and I didn't check my mail regularly and I didn't get that notice. And when I heard that I didn't have a warrant, I had to come take care of it. So I didn't get that in the mail in time. So that's exactly why I missed it.
Okay, is your address, this address here on Miller?
Yes, 908 West Miller, but I was staying at my dad's at the time at 1415 Lenore Street.
Okay, so I have here a citation that states that on or about July 6, 2024 at 12:20 p.m. at the area near the 900 block of West Miller, City of Lansing, Ingham County, State of Michigan, that you did violate Article 9, Section 1 by having a dog at large. It indicates in the remarks a dog, Millie, black female pit bull, approximately 5-year owner admitted violation. Millie got out of the door and charged a passerby walking their dog on the sidewalk. Millie latched on and bit the passerby's dog. So that's a misdemeanor. You do have the right to be represented by an attorney. Normally, we would have had an attorney here to represent you for your arraignment, but given the fact that it's Wednesday, we don't really have public defenders in the building.
That's okay.
And this is a matter that typically, if you were to provide some level of compliance, meaning there was some better security provided, or you no longer have the dog that was surrendered, whatever that compliance was, and provide evidence of that to the prosecutor's office, they have been giving or negotiating deals and or up to dismissal of the matter with that compliance. So the court's going to enter a plea of not guilty on your behalf. You do have the right to be represented by an attorney. If you can't afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. You understand that, right?
Yes, Your Honor.
Do you want to request an attorney?
Yes.
You will note that you are requesting court-appointed counsel. You'll need to make contact with the public defender's office so that they can get an updated intake for you. And you can call their main line and do an intake, okay? Otherwise, what will happen is I'm going to get you this next court date, which is a date for a pretrial, November 12th at 8:30. If you wait till then, it's just going to prolong that because they won't have done an intake. So you need to contact them today or tomorrow, let them know that you need to do an intake so that you can have representation that you requested court-appointed counsel on this matter, okay?
Okay.
And you got a copy of your next date to appear. This is probably in here.
Yeah, I do that. And
That's your date
also,
to appear there. We'll get you that notice there. Then I have another file.
yeah,
You also have the right in the dog at large to proceed to trial. You have the right to jury trial on that because it is considered a misdemeanor. You have the right to require the prosecution prove your guilt beyond a reasonable doubt. You have the right to remain silent, not have silence be used against you, or you can waive your silence in trial and testify on your behalf, understanding that anything you say can be used against you. You have the right to subpoena witnesses to testify for you and present evidence at trial that you believe show a defensive discharge. You understand that?
yes, Your Honor.
Okay. Your bond in that matter is 100 personal recognizance. And you got your next court date on that. And then I think this is a collection file.
Yes.
What is this? Okay, and these are people of the state of Michigan. I have 19-04939, and it looks like they've added some other collections on this as well, but that you have a total past due amount of $935.38 on the total amount of collections that you have here. Because it looks like in March a new case was added. Are you employed?
I am
Where are you employed?
at Trusted Herb Care.
Say what?
Trusted Herb Care LLC.
Okay, you were supposed to be making payments on this, it looks like.
Yeah,
Maybe $25 a month. It looks like you have been making some payments, but some of these extend back to 2020. You had a payment a couple times of $25. Once there was a payment in 2023 of $105. You made a $16 payment, a $15 payment, and a $20 payment.
I know it's not much. Like I said, when I was incarcerated, you know, that's the route why I really haven't been paying on, you know, that as well as my felony probation that I'm on. They kind of understand what I'm going through right now with, you know, trying to get my utilities back on and, you know, I was behind like $1,000 in rent. So they just wanted me to take care of that stuff before I started paying on my felony probation, but I could definitely have some money to pay on that today.
Okay, I'm not saying that you need to make a payment today, but you need to get back on a payment plan.
Okay.
I recognize you were incarcerated and now you're just getting back your children back. And so you're still on probation?
I am until June.
When are you gonna make a payment on this thing?
Today.
How much?
I'll make a $25 payment today.
When are you gonna make, are you agreeing
I
to
get
make
paid
a
every
payment
Friday.
$25 a month?
I could probably do 50 a month.
Now, I don't think you'll pay $25 today, and then you'll be paying $50 per month on the 23rd of each month. As long as you make those payments, this won't go into warrant status. If you do miss the payments without coming in and asking for extension, then a warrant issue. So if you know you're in a tight situation and you're not able to do it, it's best for you to come up here and request an extension so that you can get a warrant, okay?
Yes,
Do you have any questions?
that is all. Thank you.
Okay, we'll see you in November for your next work.
Thank you. Have a good day.
On the record in the matter of Rodwell versus Bragg 24-05086, Council McKinney.
P 86242 Elijah Cairo on behalf of defendants, Ms. Stinson and Mr. Bragg.
State your name for the record, sir.
My name is Christian.
Okay. And your name, sir?
William Bird.
Your name, ma'am? Tamara Stinson. Okay, today was the date set for hearing. This is for non-payment of rent. Council, did you all come to resolve this at all?
We did not, Your Honor, but I do believe that there are several issues of habitability. There's also a failed safety inspection, failed health inspection that Mr. Bragg did not come through and make the fixes for. My clients, since they live in such squalor, have not paid their rent because they put them on notice about the issues that they were having. They still haven't been fixed. This, may I approach the bench?
Yes.
This inspection is from March, and May was when he was supposed to make the fixes. They still have not been made currently in the home.
Okay, so there's a defense or a proposed defense of habitability? Is that, okay. You can have a seat. You can proceed with your case.
Okay, yeah, the inspection that was done, that we've made several attempts for them.
Well, you first need to establish that you have a right to an eviction for a non-payment of rent. The inspection issue is their defense. You gotta establish your case if you want a hearing that they owe you rent.
Yeah, the only rent we received was April. May.
So the last time you received rent was April?
Was May.
I'm sorry, when did they move into the property?
They moved in April.
Of this year?
Yes, I have the letter.
I need you to speak up louder, number
Oh.
one.
Oh.
It's very hot in here. I don't know if you noticed.
I'm sorry.
I'm wearing a robe. And you might be okay with your coat on. I'm not okay with this robe on. I had to turn the fan off because your voice is so low and I'm still struggling to hear you.
Okay.
So I need you to use your outside voice so that I can know what you're saying. They moved into your property when?
In the month of May, no, April.
April of 2024?
Yes,
Okay, and how much is the rent?
the rent is $850.
Okay, and so they paid April rent?
They pay April rent and May rent.
They paid May rent? And then you're saying the last time you received rent?
Yeah, was May.
May of 2024?
Yes.
Okay. And so
I have the ledger.
you have a copy of the ledger? Thank you. And you provided a copy of this to their attorney?
Okay.
This is for the address of what? What's the address?
The address, that's Lake Lansing Road.
What's the address?
That's 1103.
Is that in the city of Lansing?
Yes, one.
Okay, in Ingham County?
Yes, one.
Okay, and so I see that they paid rent, you said April 7th, $850 was paid,
Yes, one.
and then May 9th, 2024, $450 was paid,
Yes, one.
and then on the 26th of May, $400 were paid.
Yes, one.
And then no other payments were made, is what you're saying?
Okay, good.
Okay, any other information that you wanted to provide?
Yeah, it's just the complaint of the fixing of this. They have not been letting us, so I thought they want to move in. There's 2 units. We're taking care of the upper one. We never have problem with that.
What unit do they live in?
What?
What unit do they live in?
The down one.
Do these units have numbers on them?
Yes, this is it. Yes.
What unit do they live in?
1103. The other one is 1103 half.
How does the city number it? Do they number it unit 1 and unit 2?
Normal, we have it that, forgotten the way they put it. It's A.
A?
Yeah.
So they number the A and B?
What we do here is just half. That's what we do in our just is half.
Okay. Oh, so for example, the paperwork that you have here, does it say a unit number on it?
Okay. No. Yeah, it is mentioned, yes, unit 11 or 3.5.
and a half?
Yes.
That's their unit?
Yeah, no, that's the upper one, their own.
Upstairs, they live on the first floor?
Yes.
Okay, and so you have a valid rental certificate?
Yeah, that one's expired before this is for inspection.
You have a valid rental certificate for where they live?
No, they are waiting for the.
It's a yes, it's just a yes or no answer.
Okay,
Do you have a valid rental certificate? Yes or no?
okay, no, because it's expired.
Oh,
They are
when did
waiting
it
for-
expire?
They're waiting for this.
When did it expire?
That should be. I think what it was registered for inspection.
I didn't ask you that. What was my question?
I forgot that.
You forgot my question? When did it expire?
I forgot when it expired.
You don't even know? Did it expire in April of 2024 or before then?
I believe, because I believe within that time, I'm not quite sure. But normally we.
So you have no clue,
I
you have
don't-
no clue when it expired? You just move people in here
Okay, no,
and you don't know? Is that correct?
I believe that it's still active.
I'm sorry?
But normally when it's about to expire, we register it for inspection.
Okay, you registered for an inspection when?
I forgot. I don't have to.
You forgot when you registered for an inspection? This is not going well, huh? So how are you supposed to sustain? You can't give me any evidence if you don't have it, if you don't know. Any other evidence that you want to talk about? They said that there's habitability issues. If you can't even tell me when the inspection or the rental certificate expired, then that's not helpful for you. When were you supposed to have some inspection issues addressed? When was that?
Yeah, the thing's supposed to have been completed by around May, but we've done the upper one, but we couldn't have access for the down one.
You didn't have access?
No, I've made some requests for them to let me so that we can take care of one.
Okay, so you did upstairs, but you didn't have access to downstairs?
I will try to have access.
Why didn't you have access?
No, we try to let them if they can to let us in.
You tried to do what? I'm sorry?
To try to see if we can have access.
Okay, and they wouldn't give you access?
That we can't have a direct communication so that we can be able to come in. So we thought that moving
Since April? You've not been able to get access?
around from the month of May, we tried to.
Since May, you've tried to get access?
Yeah, I've called them on several occasions.
What days did you call them?
I can't remember.
You can't remember? How many times did you call
I'm sure of maybe up to 5 times.
them? You called them 5 times since May, but you don't remember?
May might be almost 2 times, because the other person that I have was the other person, not the one I have their contact was.
I don't know who that is. You filed this eviction. I only know their names because you put their names on the eviction. I don't know who the other persons are. Who is the other persons that you contacted? Why are you looking at them? They're not gonna tell you.
Okay, that with them in the house.
I'm sorry?
That with them in the house.
Yeah, you spoke to that person?
Yes, I called several times because it's the one that mainly in contact.
Is this person on the lease?
So,
Do you have a copy of the lease?
but I have their name.
What is their name? Ask what their name was.
We have Brad, William, and the people we have on the list, Brad, William, and Stenson Tamara.
Okay, Ms. Stinson is present and you said Brad Williams? You spoke to a Brad Williams?
I think you said Bragg Williams.
Oh, Brad Williams?
Yeah.
Maybe I think there was this thing. I thought they were there because there was another person that was staying with them.
Okay, sounds good. So you don't know who you spoke to? You don't know you spoke to in May?
I spoke with him in month of May. Then
And asked for you asked for access to the property and they said no?
No, it was said that they were said that they're going to call, they're going to scan.
Okay, And so when did they reschedule for?
No, he does never get back. We shall, that has been very a bit run ups and down. And I travel on the month of that was month of March. I was out of the country.
But you were not even talking about March, we were talking about May.
May, okay, sorry.
Okay, you called them in May is what you said.
Yeah, I
You
called
went
them.
back and forth, and then what happened in June?
In June, I think another time was in July that I called because we have.
What about June? Because that's where I am. I'm still in June. What happened in June?
Okay, I can't remember if I called them.
Can't remember about June. Okay. And what about July?
July, I called again on July because we did some work also in the upper one. We completed this.
How many times you called in July?
I can't remember.
Can't remember how many?
Yes,
More than two?
yes, more than two.
Did you all schedule a date for you to have access on that?
I didn't schedule because I was trying to see their schedule to fit in.
You didn't schedule because you were trying to see when your schedule could fit in with theirs?
Yeah.
Okay, but you had a notice from code compliance?
Yeah, the notice that I have, I'm waiting for this so that I can complete those ones, so I can.
Okay, and what about August? What happened then?
The August time, I believe I called in August, but I can't remember. I told them maybe one time.
September.
September, I didn't call September.
What was the inspection for? What is this notice that you have there?
It's just normal rental inspection,
Just a normal rental
Yeah,
inspection?
rental inspection.
Oh, okay. Any other proofs that you have that support that they owe you rent? How much are you saying they owe you?
That's that should be that's for 5 months. Right.
At $850?
Yeah,
Does your lease provide for a late fee?
yes, but if they pay for this one,
I'm sorry?
it provide for the late fees.
Okay, so you're seeking $4,250, or did you add a late fee?
I didn't add that. If this one can come out, or I
You,
thought,
you said if they pay that, you'd waive the late fee?
yeah, or even make a payment arrangement.
Okay, okay, got it. I understand. Anything else that you believe is evidence to support that they should be lawfully evicted for non-payment of rent?
Right.
Okay, you can have a seat, sir. Mr. Tyra.
Hello, Your Honor. As previously stated, I think that, well, I'm in knowledge of Ms. Stinson and Mr. Bragg having several serious health violations and habitability issues during the course of the stay of
Did
this.
you want to call them as for testimony?
Yes, ma'am.
Who do you want to call?
Ms. Stinson.
Ms. Stinson? And when you get to the stair, just raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat. You can proceed to question your witness.
Thank you, Your Honor. Good afternoon, Ms. Stinson.
Good afternoon.
Could you please state your name for the record?
Tamara Stinson,
Could you spell your first name for us?
TAMARRA.
Thank you. How do you know the plaintiff?
I know him because he's a landlord. He worked the downstairs apartment from him.
Okay. What was the address for the residence that you lived at?
1103 Lake Lansing Road.
Okay. Can you tell me how you came to live there? Like, what what was the process like?
I came to live there really, I really didn't even know him from when somebody connected him to us. We paid deposit and then we moved in. That's how I really.
Do you know about when that move-in was?
It was in, I believe, April.
Okay.
April this year.
And at the time when you first moved in, did you guys make an agreement on how much rent would be and how you should pay and all that good stuff?
Yeah, we made an agreement that rent was $850 and the late fee was $20.
You said the late fee was what?
$20.
Did they-
Down.
Okay. Did he tell you when you had to make that rent payment by before the late fee accrued or anything? Or was it just,
We
in the
pay
month?
rent every month.
Okay, okay. Can you describe generally for me what the residence was like when you first moved in?
It was okay, but it really wasn't like living like. family.
I'm gonna show you something that's been marked as Exhibit B.
Okay.
Your Honor, may I approach?
Yes. You have to get her to mark the exhibits.
Right, can you explain to me what you see in this picture? Can you tell us about it a little bit?
This is him when we moved in.
This was there when you moved in. Can you
Yes.
tell me what I'm looking at?
It's a board outside the window. At first, I thought the window was broke. I don't know. They just kind of, I thought they were gonna take it down. But it's just a board, a cardboard nailed to the window.
And are you still getting bugs or rodents, even though there's that board there?
Flies and all that, yeah.
Okay.
I'm sorry, where's this? What window is this?
This is,
This is the window to our kitchen. So this is in our kitchen, the back. So you can't see out the back window. To see the back, this is the window in the kitchen. Okay, and so there, you said there's a cardboard? Yes, it's like a, like board, like wood. I don't know what type of cardboard wood it is, but it's on the window. Okay, so the window's boarded up from the inside or the outside? The outside. Okay.
I do have this picture as well, Your Honor, to show.
Any objection to their admission to that as an exhibit?
Yeah, you are not, that is right. What happened was,
No, I didn't ask you what happened. I asked you if you objected to that as an exhibit.
okay, what I'm admitting that is body.
No, you can object if you believe that it's not accurate or it's not, you don't know how the picture was taken. It doesn't accurately reflect what that window looks like. That's when you can object. This is not your time to explain what happened. You'll have time later to explain your side of that window, okay? But now I'm just asking if you had any evidentiary objections to that exhibit. And it does not sound like you do.
No, because I know that it was body.
You know it was what?
It was body, but the windows, everything is cut, it's all right.
Okay, that exhibit is admitted. You can publish to the court.
I have another one, Ms. Brad. Just to refresh again. Take a look at that and tell me what this looks like, what it is, can you explain that picture for us?
Okay, this picture is the sink in the bathroom. When we moved in, it was leaking real bad, like real bad. We couldn't use the bathroom sink at all until one of these screws, we twisted it a little bit, it stopped leaking like that. But this is under the bathroom sink.
And what is that substance that's near the bottom where the wood is looking a little bit warped?
It looked like mold
Okay,
all around it. Yeah.
I would like to publish the exhibits report.
You want to admit, what is it marked as? Exhibit?
Exhibit marked E.
This is a defendant's exhibit E. Did you have an objection to defendant's exhibit E, Mr. Nwabu?
Your Honor, that's,
No, just an objection. You're gonna get to explain it.
Do you know what it is?
I know that when they moved in, none of this thing was here.
Okay, but are you saying that's not the sink in your house? Is that the sinking in the home, in your home? Okay, well, we're gonna admit it in the interest of time.
Thank you, Your Honor.
It can be published to the court.
Now, Ms. Bragg, I think the court has seen a few different instances of some pretty not okay things.
Yeah.
Were there any other maintenance issues that you guys had?
Yes, the venter in the bathroom, we can't turn it on because the lean system is in there. What's in the bathroom that you can't turn on? It's like, like a vent.
The
like
vent
in the
fan, you
bathroom,
said?
Okay,
So it's went to off, we can't turn it off because it make a loud noise,
Mhm.
like it don't work. It don't work at all.
Yes, ma'am. Anything else?
I don't understand, I can't hear what she's saying.
You gotta speak up and try to remember not just a lot of things, we need some specifics. What else?
It's up besides the floor plan, that's about it.
You said the floor is doing
Yeah,
what?
it's like, it's not straight up, it's not no straight floor like this. It's like leaning a little bit.
It's buckling maybe?
I believe so, if you wanna call it that, it's like, it's not up, it's leaning.
Where is this located?
This is located really around the house, in the dining room, in the living room. Like if you put something on the floor, it'll roll the way it's slanted. But yeah, that's what it is.
Have you had any issues with heater, appliances, stoves, anything of that nature?
Oh, yes, the stove light, you can't use the bottom stove. You can use the top stove if you click a lighter to it. But the bottom stove, where you press it to make pizzas, that don't work. The stove part, like, don't work at all. You can't use it. And Annie did that since we moved in.
When you say bottom stove, are you talking about the oven portion?
Yes,
Okay. So the oven doesn't work and then you have to light the pilot for the stove?
yes, you gotta light the top of the stove for it to use it.
So it's a gas stove?
Yes.
Any issues with water, heat?
Bathroom, when you turn it, the faucet to the hot water, it's barely water come out, hot water don't work, period. Hot water ain't work since we moved
In the whole home?
in the whole home. Then downstairs, when we do that, hot water ain't work since we moved in. We have to go somewhere else to take a shower.
Okay, thank you. Has the city, this is gonna sound like a silly question, but has the city ever sent anybody over to inspect the residents?
Yes,
Okay, why?
that's fine. Cause we really needed an inspection for that house. We were saying that something was off, but we can put our things to it.
Mhm.
So we had an inspection done with the house. And I was trying to get help with rent anyway,
Mhm.
to help with rent. So they said like, if you get the nice inspection stuff, then you can try to get help with rent. I seen the inspection thing and we definitely got enough
Mhm.
from that house.
Now, while you guys have lived there, has the property ever had a red or a pink tag that you
Yes.
know of? Can you
Yes.
tell me a little bit about how your understanding of that?
First when we moved in, it was like a sticker on the window, a red sticker on the window. We really didn't know what that was until I tried to get mail sent there. And they said the property was red tagged and my mail couldn't get in there.
Mhm.
Then we walked up to the house and see this red paper on the door. It said something about $5,000 and some dollars for property tax and something about foreclosure hearing on this property in February
Mhm.
2025.
Mhm.
Something like that, yeah.
Okay.
That's it.
Did it look like this? Okay. Do you mind if I approach your arm?
No problem. I just have a quick question. You said this is for the witness. It said the red sticker was on the window when
Yeah,
you
it was
first
a-
moved in?
Yeah, I seen it on the window, but it's like somebody tried to, peel it off,
Mhm.
peel it off the window, so it's still some there, but it's really not there, like somebody tried to break it off.
Okay, so that was in April? Thank you.
Look familiar to you?
Yeah.
Where'd you find that?
On my front door.
This was on your front door. When did you find that on your front door?
I found this on my front door, I believe like a couple months ago.
Mhm.
I just walked up to the door and it was in a plastic bag on the front door on the handle.
I would like to publish this to the court for the record, if that's okay, Judge.
It's been marked as what exhibit?
Exhibit F.
Could you show Mr. Robin? Any objection to that as an exhibit?
This one is foreclosure for this, it's just for tax, property tax.
It's admitted. Thank you.
Now, Mr. Nwabu said that you guys, the last rent payment that you made was in May. To your best recollection, when was the last time you guys made a rent payment?
Because we really don't talk to him, we talk to his wife. He don't handle business, his wife handles the business.
You have proof of that payment?
I do not.
How do you make your payments?
He has.
Excuse me, where are you talking? You make payments in cash?
Yeah.
To his wife?
Yeah.
And they don't give you a receipt?
No.
Why are you talking, sir? You have every right to call whatever witness you want, but you can't talk when it's their turn, okay?
Have you ever let your landlord know what issues were going on throughout the course of you living there? Because he claims that you guys were not able to let him in. Do you ever remember him asking to be let in, asking for access to the unit, asking for access to the property? Did he ever follow through with that ask?
He asked me one time, his wife actually called me to get let in to fix the hot water tank. Wasn't nobody there at the time. So I told her to come on back. She never called me back since that. We told him that we had problems with the water when we moved in. Then somebody came and started working on the heater downstairs. We really wasn't worried about the heater because it was summertime, but we needed water. And they didn't come and fix the water. They just was focused on the heater downstairs, and they barely got that to work.
No further questions, Your Honor.
Mr. Nwabu, do you have questions for this witness?
The question I have is, you mentioned that you never have, since you moved in, you don't have hot water.
Never had hot water. That the bathtub don't work.
To the best of my knowledge, the hot water is working. The person upstairs using hot water.
Is this a question for her?
Yeah, that's one of the questions because I was surprised about.
Oh, no, your question is if the people upstairs have hot water?
Okay, no, it's just that she mentioned there's no hot water.
I get it, but you're only asking her questions. I'll give you a chance to give your statements, but right now I'm just asking if you have questions to ask her.
Have you informed me that you don't have hot water?
Yes. I informed the wife.
I never have knowledge. And normally each time if we have anything on.
Mr. Nwabu, we just went through this at the last question. What are you doing right now? Asking her questions. Any more questions for her?
Okay, for now.
Thank you for now, Your Honor.
Okay, you can be excused.
Okay.
Any other witnesses, Mr. Tyra?
No, Your Honor.
Okay, let's see. You wanted to give some further testimony or call more witnesses, correct? Well, share what you wanted to share that you kept trying to share when you was asking her questions first.
Okay, Your Honor, what I wanted to say, like hot water, they mentioned that they don't have hot water.
They mentioned it to you prior to today?
No, it's today that I'm hearing it again.
Okay.
When we have problem of hot water, it was taken care of. And the person upstairs, he cannot stay without hot water because they use one water.
When did they tell you that they didn't have hot water?
I can't remember. There was a time we had that I think that was the water heater was fixed.
Okay.
And it was taken care of.
When was the water heater fixed?
I can't remember what.
Who fixed it?
That was done.
Who did it?
The mechanic said done.
Who is the mechanic that did it?
Yeah, it's a mechanical person.
What's the name of the mechanical person that did it?
Okay, that was Dan Hazel.
Dan?
Yeah, Dan Hazel.
Okay, and he installed a new water heater?
It was, the water heater was there. It was either the pilot was going out.
Okay, so he serviced it?
Service it.
Do you have a receipt for the service?
I don't have, I can check for the receipt, but it was taken care of.
Today's the date for the hearing, and let you either have it today or you don't. Do you have a receipt, sir?
No, Your Honor.
Okay. Let's see. And then what was the other issue you wanted to address?
The other issue they mentioned about the concerning the foreclosure things, we're making payment, make payments.
This issue?
Yes. Well, normally we take care of those taxes. We never have any issue into taking care of.
Okay. And just to be clear, Exhibit F is a notice of show cause hearing for judicial foreclosure, not a city red tag file. That's what you were explaining, correct? Okay. Any other information you wanted to share before you call your witness?
Other one was when this concerning the window that was ordered, the one for this thing was people they kept on before breaking the glass. But
Who
that
kept breaking the glass? Someone kept breaking the glass?
Yeah, but everything is working well.
When would, this was before they moved in?
Before they moved in.
Okay,
It's
so,
in my mind to remove it.
okay. So you came later to remove the
What is-
board? Did you ever remove the board off the
No,
glass?
not remove that. I can take it off. There are so many.
Okay, but they testified that they're getting insects in rodents in the house.
No, they never mentioned any of that. I never have any knowledge of.
You didn't have any knowledge of
No, the
insects and
Bible shall
rodents?
take care of that.
Okay,
I don't have
okay.
any of those. Even they mentioned about this cabinet, we have the cabinets were new cabinets. We have both kitchen, one.
You're saying this was a new cabinet?
The cabinet we had there was new cabinet. So I don't
When were
have-
they installed?
What is, John?
When did you have the cabinet installed?
The cabinet, the one that I don't know, I'm not sure of but for the kitchen one was installed, I believe either the month of either February or March.
In March?
March.
This is the kitchen cabinet?
No, that's the bathroom.
This is the bathroom. When was the bathroom cabinet installed?
Bathroom cabinet, I've forgotten whether it was new one, but this thing is not the experience we have when they moved in. That one was clean and it's clean. We
So
can't-
you're saying that this was fine, and then after they moved in, it's only been less than 6 months this happened?
No, we cannot just see this kind of thing.
You can't do what?
I don't have a can't believe that this thing is there.
I'm not asking if you believe that this is there. That's not what I'm asking you. I can't believe that people live with this either, but that's not what I'm asking you. I asked you, when did you replace it? You don't have any pictures of what it looked like when they moved in?
Okay, no, Your Honor.
Okay. Any other information you want to provide?
No, Your Honor.
You can call your witness. Off the record, is your matter ready to go?
I think it's submitted to the right?
Oh, okay, you're all set.
Thank you.
We'll get you a copy.
Can't do a trial without pen.
I'm looking for. Are you ready with your witness?
She's coming, but I don't know how far she was here before.
She's coming.
She's coming, yes. I think she's down to put in the.
What's your name?
Gloria Moore.
You can come up, ma'am. You gotta come this way. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat, please. Please state your first and last name.
My first name is Gloria Mobu,
Spell your first and last name.
Gloria. My last name is Nwobu.
Mr. Nwabu, you had questions for her?
Did you receive any letter from, sorry, the month they mentioned there, they made payment on month of July.
I did not receive any payment in the month of July. I met them, they said they are asking for help for the payment.
You said that they asked for help, you said,
That they are trying to get help for.
in July?
In June, July.
Any other questions?
Okay.
Okay, ma'am, are you the person that they talk to give their payments to?
Yes.
How do they pay you?
They pay once through Cash App when they move for security. Then they pay you through one. I think their mother-in-law. That's what that give me cash.
Okay,
And then that gave the receipt.
you gave a receipt?
Yes.
When did they pay you through Cash App? So when they moved in?
Yes, that was April 5th.
Okay,
For the security.
and so the payment in May, you said was in cash?
Yes.
Do you have receipts for their payments or a copy of their receipts?
This is one of them.
So, attorney, Mr. No, you have a seat. He'll come to you.
Okay, sure.
Correction, Your Honor.
This is the one gave me. This is another one. In the same name. Gave me 400.
Are you saying those are the only payments that they made?
Ah, that-
Okay, any objection to her showing those to the court as exhibits?
No objection, Your Honor.
Okay, Yolanda, can you get that done, please? Thank you. Okay, so did you give them a receipt for April or just May?
I gave them receipt for April.
Oh, okay, but that's not what this is. This is just a May receipt you're showing me.
April.
I see a receipt May 9th for $450. But did they make another payment in May?
No, 2 payments, yes, in May.
Okay, but you're only showing me one receipt. Is there another receipt?
Yeah, it's there, it's there.
Goes from May to. Okay, I do see it here. It's skipped. May 26th.
Yeah.
For $400. You can give that back. Any other questions for Mr. Nawabu?
No,
Did you have questions for this witness?
You said that my clients made a payment for me, but I did not see the April payment in there. You said that you have a receipt from Cash App.
We paid April 7th.
Mhm.
That's when they moved in.
Okay.
That's the one that we put in the list for moving in. That was they gave 500 from April 5th in Cash App for security to move before they moved in. So but they gave 700 and 850.
Okay, so they gave you 500 April 5th and then.
No,
April 7th.
850 April 5th.
850 they gave you.
Yeah. And April 7th, 850.
So they gave you 850 for both April 5th and April 7th.
And that's for security and
You
rent.
said that's a security fund. So okay. No further questions, Your Honor.
Thank you. Ms. Nwabu, you may be excused from the stand. Any other evidence today?
No, Your Honor.
Okay, you can make argument. I know what his argument is. Ma'am, you can have a seat. You can make your argument.
Your Honor, it is my belief that because of the severity of the health issues that they have had to deal with, which includes mold in the bathrooms, no access to hot water, issues with the furnace, and the rodent issue that they've had to deal with, I believe that they are due a full rental abatement, if this court so finds fit. We would also ask that you make a judgment in favor of the defendants for possession, as well as dismissing the case.
You have anything you want to say, Mr. Nwabu?
I don't know what I wanted to say. Yeah. We did all that we could under normal listing. If they would have what access for the ventilation. Then, if you are on or looking to whatever, the way you just run it out. But the important thing for me, if they want to stay, they're supposed to make payment for it and let us stay so that whatever that we do will be done. I wanted to work with them.
They're supposed to do what?
If they could just give us access to take care of what needs to be taken care of and making payment towards the rent.
Okay. Have you have any other argument other than that, sir?
Not for now.
Okay, I've heard, you can have a seat, sir. Both your testimony, your wife's testimony and testimony from one of the tenants, Ms. Stinson, in the argument of her counsel, you indicated, sir, that this is a breach of a landlord-tenant agreement for non-payment of rent, that there has been no rent paid since May of 2024, and that the tenants now owe you a balance of $4,250, not including late fees. The tenants indicate that they don't believe that they lawfully should owe you rent because of the conditions of the property. The conditions indicated today involve issue with a boarded up kitchen window, which the testimony was that there were insects and rodents entering into the property. There was the defense exhibit B admitted to support that testimony, and then there was defense exhibit E of a sink, which was testified to be the bathroom sink that is clearly molded, and the bottom of that sink is has deteriorated and it's kind of buckled due to the moisture, and it appears that there's even some dark black moldy substance on the actual piping, and then there's a broken paint tray under that pipe as if it were there to maybe gather some water. There was testimony that the vent fan in the bathroom was not working or in working order, that there was an issue with the floor, the dining room and the living room floor. It's not clear what that issue is, and I'm not sure if those issues would warrant habitability issues because I don't know what they are. The testimony was that the tenants were not able to use the stove without lighting the pilot, and that the oven had an issue that they never were able to use the oven, that the bathroom faucet barely released water, that they never had hot water from the time that they moved into the property, and that they have had to take showers outside the house elsewhere. They testified that there was an issue of a red tag to the property, and that they were unable to get their mail forwarded there when they first moved in. They've admitted an exhibit F. However, exhibit F is not a red tag. Exhibit F is a notice of a show cause hearing for judicial foreclosure for lack of tax payment. However, there was also testimony that this unit lacks a valid inspection sticker and lacks a valid certificate to be a rental. And I questioned you extensively about that once I had that information. And you could not give me any information as to when the certificate was last valid, when you were supposed to have an inspection. Your estimation was that it likely expired just before these individuals moved in April 2024, and that there was no inspection because it was their fault because they would not let you have access. I asked you when you tried to make access, you couldn't give me times, you couldn't recall when you requested, but you did believe that you were called a couple times in May, but you don't know who you spoke to, and it wasn't based on your testimony clear that you spoke to either of these individuals. When I asked you, who did you speak to? You gave me some information, but none of them sound like it was these people. It wasn't the names of these people. You said it was another person. Then you said that you couldn't recall if you spoke to them at all in June. Then you couldn't recall, or you called them maybe in July, but you can't recall how many times. You didn't call them in August, maybe once if you did call them in August, but you can't recall, and that you didn't call them at all in September. It's now October. As we were waiting for your wife to come back to the court for her testimony, the court did pull up the city website to see when the certificate expired. The certificate expired in 2023, before you even leased anything to them. You had no lawful authority to lease this as a rental property to these individuals. And it didn't expire just before they got there. It says here clearly on this public city website that your certificate expired and that they had tried to come January 25th, 2020. Well, let me go further than that. Looks like it was expired before then. There was some kind of transaction in February of 2023. It says on April 18th, 2023, code compliance rental late fee was assessed of $120. On September 15th, 2023, a code compliance rental late fee was assessed again of $120. This is because your certificate had expired and you had not gotten your certificate renewed. There was an inspection that I'm assuming was scheduled because in January of 2024, this year, January 25th, it said an inspection no-show fee was assessed of $65, which means that you were scheduled for an inspection and you or no one was there to let them in for the inspection. It had nothing to do with their access. They didn't even live there in January 2024. And so that you cannot put that onus or responsibility on them. Even if I were to believe what you said, which is that you made communication with them, which based on your testimony, I don't by any means believe that you did your due diligence in trying to communicate with them about needing to get an inspection. But even if I believe that you made some calls to them to try to get access for this inspection, I would have to believe that they completely blew you off and they didn't want this property inspected, and then that you had no other recourse. And I can't believe that because I know that as the landlord, even if they don't give you access, and you've not provided me a copy of your lease, so I don't know what the lease agreement is, but I know it's reasonable to understand that you could have provided notice in advance, typically for 24, 48-hour notice, that we will be entering the property during this time. So whether they give you access or not, you are the lawful owner. You have a duty here under the law to get it inspected and certified because you're already renting it unlawfully. And to tell me that they didn't give you access and you're traveling and you're living your best life out in East Lansing while they're living in your property that's not even properly inspected, and you think that they're supposed to pay you and then you'll work out the issues, you are grossly mistaken about how this process is going to work, at least before this court. You're going to keep the property in conditions appropriate for the tenants before you move them in there. You're going to get it a certificate properly issued, as well as have it inspected before they issue or move in. There shouldn't be any testimony about they didn't have any water and you had to send someone to get a water heater fixed. And I asked you who, and you can't tell me who. You don't have a copy of any receipts. You provided no evidence other than testimony. They've provided receipts. They have pictures. I know you're saying that this boarded up picture is something that the window was fixed, but the testimony they have doesn't lead me to believe that it was fixed. It leads me to believe that that board was up there and that they said that they're still getting insects and rodents in through that access point because it has not been fixed. And so because of those things, I do not believe that you have a lawful right to $4,250 because I think that you neglected your duties. Had you had a valid certificate when they moved in, I would have abated this at a percentage because I don't know that what I see here based on the evidence is enough to give a full abatement. I think it would have been a large abatement if they don't have heat and hot water, they can't use their stove, there's mold. But because you don't even have a lawful certificate, I'm not ordering them to pay you anything because you have no right to rent the certificate. And then you go claim these tax rewards for something that you didn't do your lawful duty on first. You do what you're supposed to do first. And Mr. Nwabo, you have multiple properties in the city of Lansing. You should be well versed on the law as it relates to how to rent and to maintain a property. And so I can't even give you the benefit of the doubt on this one. I think you need to do better if you're going to be renting around here. As to the abatement, I'm going to grant the request for a full abatement. However, you need to vacate this property within the next 21 days.
Okay. Yeah.
You need and turn over the keys.
Okay.
Sounds like you're not able to shower there or live there anyway, so there shouldn't be an issue. I don't understand why people say they have these issues in properties and then they don't leave. But I don't know what your lease agreement was because I wasn't provided a lease here today as part of the evidence. So maybe you thought you were tied into the lease. I'm going to give you now an opportunity to leave the lease because I don't believe that the property is habitable. In addition to that, I have what was the defense exhibit A, and it indicates, you said that they live on the first floor unit? This indicates multiple issues on the unit that they live in, including deterioration to doors, loose hinges, plugs that are loose, a leaking waste pipe, leak in the kitchen sink, loose toilet connection. It says the bathroom vent is defective. It says the window glass is broken and or missing. It says that there was a cracked glass in the north kitchen window has been boarded over. This was from the City of Lansing Code Compliance. So your testimony that it's fixed is not what the City of Lansing said when they came out and inspected it. It said that there's no a lack of hardwire smoke detector. There was trash stored in the kitchen bags and on the back porch, which I can't attribute to him. If you live there, you have no business leaving your trash around there. Paint was peeling on the trim, paint and protective coating around the garage, which I'm not really too concerned about. There's issues, it says, about old water heater and furnace that was left in the basement. The smoke detector was beyond 10 years old. There was no guardrail at the open side of the basement stairs for security reasons. Some screens that were missing, some other deterioration to the property and broken missing pieces in several spots to the siding. I believe it says the chimney had a deteriorated mortar brick cap and the chimney is leaning. The city ordered that you address some other window issues and some issues, it says, to make the area weather tight and in good repair. This was ordered back in April 2024. You were supposed to be in compliance by May 29th, 2024. It is almost October 29th, 2024. That's why your inspection sticker is on hold, because you've not done what you were supposed to do and you can't put it on them. Judgment in favor of the defendant. Mr. Tyra, can you give me a order reflecting my judgment?
Yes, ma'am. I'll send that to the court.
Yes, you can file that through my file.
Yes,
Any additional matters for today's record?
so much.
You're all set.